at Santa Fe? All right,
Put down the board here.
good, good. All right, and let's see. So we have member or Vice Chair Trujillo Davis, member Bitzer, looks like member Garcia. Yes. Is that member Honker with you? Yes.
It's good if you can't see me.
Okay. Well, it looks like we do have a quorum here. Let's see. Is member Ely there?
No, can you hear me? Can you
Yes.
hear me okay?
Yes.
She's not here. I recall she had recused herself from the Roper matter, so maybe that's why she's not here.
That's correct. Okay, wonderful. Well, I think we can get started with our meeting. Ms. Jones with you as well?
Ms. Jones is out today, so it's me, Maria Corral, who'll be handling the meeting.
Okay, wonderful. Thank you for that clarification. And I apologize if there's any background noise and out here on travel, but with that, well, let me pull up the agenda here, my side, and make sure we can pull that up here. Let's see. All right, so officially we'll start the meeting, and Ms. Corral, can you please do the roll call for us?
Yes, Member Bitzer,
I'm here.
Member Ely, Member Garcia,
Here.
Member Hunker,
I'm here.
Chair Suina,
I'm here.
Vice Chair Trujillo David.
Present.
You have a quorum.
Remember, you just joined us.
Hey, good morning.
Good morning.
Good morning, Member Ely. Thank you for joining us this morning as well. All right, so thank you. We'll let the record show that Member Ely is also here. And let me make sure I move everybody to the stage here. That needs to be Member Bitzer. Give me 1 second administratively here. Trying to make sure. Okay, I can see everybody. Let's see. All right. Thank you for that roll call. Next on our agenda is the approval of the agenda. So I'll look to the members, and I also want to introduce our legal counsel, Carl. Would you mind introducing yourself briefly?
Good morning. My name's Carl Reisted. I'm with the Attorney General's office. I am on loan to you guys from a different division. I normally handle general civil litigation and prosecute before some boards in administrative licensing cases. But since we don't do that for you guys, there was no conflict of interest, and I volunteered to serve as an interim counsel until Mr. Moander's replacement can be hired, and they anticipate hopefully in the next couple of months for that to take place.
Thank you for that, Mr. Reisted. I appreciate that introduction. So with that, I'm looking to our members. If there's no changes, I'll look for an approval of the agenda.
I will move to approve the agenda.
Thank you, Member Hunker. Thank you, Member Bitzer, for your second. With that, Ms. Corral, would you please do a roll call vote?
Member Bitzer, how do you vote?
I'll vote yes.
Member Ely,
Yes.
Member Garcia,
Yes.
Member Hunker,
Yes.
Chair Suina,
Yes.
Vice Chair Trujillo David.
Yes.
The motion passes.
Thank you, Ms. Corral. Appreciate that. And we'll go to the next item on the agenda, which is the approval of January 27, 2023 regular meeting minutes. I know Ms. Jones had sent that out to us for our review prior to this meeting. Do any of the members see any changes that need to be made? Seeing nobody raise their hand, I'm gonna look for an approval of those meeting minutes. Motion.
I'll move approval of the minutes.
Thank you, Member Bitzer.
I'll second that.
Thank you, Member Garcia. With that, if there's no further discussion, Ms. Corral, would you mind doing a roll call vote?
Member Bitzer, how do you vote?
I vote yes.
Member Ely?
Yes.
Member Garcia?
Yes.
Member Hunker?
Yes.
Chair Suina?
Yes.
Vice Chair Trujillo Davis?
Yes.
The motion passes.
Thank you so much for that. Yes, Member Hunker, do you have a question?
Yeah, just a question. Who normally signs the minutes? Is that the chair or the secretary?
Good point. I think in the past it was the secretary. When we lost the secretary, then it turned to, was it you, Vice Chair, that was signing the minutes?
No, it's always been the secretary that signs minutes.
Yeah.
Well, I noticed that these minutes were drafted up for the chair's signature, and that might be appropriate since I was elected secretary at that meeting. So, but I'm fine signing them as well. But,
That's a great
Maybe-
point.
I'm fine either way. It might be appropriate for the chair to sign it since the election of the secretary was one of the items at that meeting. But I'm fine signing them in the future.
Okay, thank you so much, Member Hunker. Yeah, I'll sign these ones, and then for future meeting minutes, we'll make sure that you're the signature on these. Wonderful. Wonderful. All right, and then next, if there's no further discussion on that, we move to the public comment period on our agenda. And Ms. Corral, do we have anybody wanting to provide public comment?
I have not received any requests for general public comment at the moment.
Thank you. And there's nothing on our no hands raised or anything on our platform this morning, right?
I have not received anything on our chat either. That's normally where they let me know.
Okay. All right, and just checking my screen here as well. I don't see anybody raising their hand or turning their camera on for public comment. So with that, we'll move on our agenda to discussion regarding pending litigation. And so for that item, Mr. Reistad, would you please guide us through that item?
Certainly. There is one outstanding item that I've become familiar with, and I've actually entered an appearance is our legal term for that. It's in the case of the Independent Petroleum Association of New Mexico versus the board. So that is an appeal. It's at the Court of Appeals, and the case number is 40,546. And my update on that, other than filing an appearance as your counsel, again on an interim basis, but the other update is the Department of Environment, or excuse me, the New Mexico Environment Department has decided to intervene, and they have a lot of knowledge and expertise in this area. And I spoke with the chair regarding this, and we concurred in that motion that's been filed. It's awaiting, my understanding is that it's awaiting a scheduling order from the Court of Appeals. That based on the timing of when the appeal was filed, that could be any day or in the next few months, that there will be a schedule put into place as far as items that need to be entered in that case at the Court of Appeals. And so that's all I have on that matter. And I believe that concludes my report on pending litigation.
Thank you, Mr. Rystad. Members of the board, do you have any questions on this item? No? Okay. With that, just making sure one more time here. Wonderful. Thank you, Mr. Rystad, for that update to our board, and we'll just keep watching on that. Continue to have you as an interim helping us keep an eye on that. Appreciate that. All right, well, that takes us to the next item on our agenda, which is EIB 22-34 in the matter of the petition for hearing on air quality permit 9295 Roper Construction, Inc. Alto Concrete Batch Plant, and the deliberation and possible decision on this item. And so with that, I know we've received the hearing officer's report and packet. And I just want to note that Mr. Ball, we're on the record, right, on this? Wonderful. Okay. Before we begin deliberation, I'm just going to check with our legal counsel for today. Mr. Rystad, is there anything that you want to share with the board or things that we need to be aware of as we enter deliberation?
Certainly. I did review the report. I see it was received by the board on January 18th. And about a week ago, I reviewed it at length and made some notes. My first comment or bit of advice is directed not only at this case, but in general. I would advise that if, so there was a hearing officer appointed, obviously, and this is his report. So in the future, I would advise that that in the order appointing the hearing officer, that he or she be directed to enter recommended findings of fact and conclusions of law. So that was the first thing I noted in this particular report, was that the only recommended findings of fact and conclusions of law in this case were on uncontested procedural matters. And the hearing officer specifically noted that the order only the order appointing him did not direct him to prepare proposed finding of facts and conclusions of law on the contested issues in this case. So just a point on that. And so he did, as you know, he entered some comments about those contested issues. In reviewing those comments, and so I would obviously advise you to adopt the hearing officer's procedural recommended findings of fact and conclusions of law. Those are very well laid out. You will have to decide some contested issues based on your own knowledge and expertise and the evidence that you've reviewed. There are no specific recommendations from the hearing officer, as you know, as far as how to decide those contested issues. Along those lines, there were two things that I noted for you to decide. And this may be all water under the bridge for you all, but since I'm new to this, I just want to point these out. On page 35 of the hearing officer's report, there were conflicting technical opinions regarding which AP 42 emission factor is more representative of operations at the proposed facility. So that may be something you would need to decide today. And then the other point I noticed on a contested issue was on page 52. And that would be whether this board wants to deviate from a longstanding practice to require proof of water availability. And I'm sure you'll recognize the issues that came up with that, as far as whether can decide, whether you should decide whether water availability is part of this process, or if it's simply based on the air quality permit. Those are the only comments I have at this time, but I'm happy to entertain questions as they come up from the chair or any members of the board. So.
Thank you, Mr. Rystad, for that that introduction on this matter. I just want to also note, Member Ely, and I know you had a just putting it on record. You wanted would you share with us your position just so we have it on the record?
Yeah, as the board may recall, during the hearing or prior to the hearing, I recused myself because of my previous role as division director overseeing the Air Quality Bureau at the time that the permit was issued. And so I will not be participating in these deliberations, but I will listen in. Thank you, Chair Sweeney, for giving me this opportunity to state that.
Thank you, Member Ely. Appreciate that. All right. So with our members of the board, yes, Member Hunker.
Just a question for Council Rystad. Could you outline what our potential options are for a decision today? Kind of what are the things we could decide on this, and what are the limitations on that? That would be helpful to me.
I will state, first of all, I am new to environmental law. I have general knowledge about environmental law, but not specifics. So that's going to limit my ability to give very detailed advice in this matter. But I will say in general that you need to decide whether you would like to go ahead and approve the permit today. That's one option. Just plain and simple, without any clarification or restrictions. Another option would be that you could decide, as I mentioned before, whether to require proof of water availability as a condition of issuing the permit. That was one of the issues that I mentioned earlier, that the hearing officer noted that there is a longstanding practice to not get into that issue, not to consider that. So there's a question of whether you can or should. In other words, you can deviate from the longstanding practice of not considering the water availability for these type of permits. Whether you should or not is in your purview, but legally you have the right to do that. Finally, you could deny the permit based on concerns that the public has, people that live in the area, the groups that have entered an appearance in this matter and before you, and I think, like I said, unfortunately, my comments will be kind of have to be in general as far as those three, different options: straight approval with no conditions, approval with or temporary or provisional. Again, you could, for example, with the middle option I mentioned, where you want to consider water availability, you could allow. I know this permit's been amended several times. You could allow for it to be amended again for the condition that that Roper provide more information about the water availability if you decide to get into that area. Or again, you could just deny the permit outright based on concerns that the hearing officer addressed and that the general public.
So I assume when you say deny the permit, we would uphold the decision made by the department, their deputy secretary in the initial action.
That is correct, sir.
And I assume the permit, if we were to decide to overturn the initial decision by the department, the permit that would be issued would be the one that was proposed by the Bureau staff at the time of the final decision. I just want to be clear on what would the permit be that we would be choosing to issue.
That's an excellent question. I'm not sure I have a great answer for the status of the permit. Maybe the chair would be, since she's more familiar with it, Madam Chair, if you could address that, because I know it's been amended, but that I'm not quite sure about the correct answer to that question.
That's correct, Mr. Rystad and Member Hunker. The amended permit is the one that has been the latest file, but also that there was some also questions about the process to get to the amended permit, if you recall during the testimony. But that's the permit, again, to your to your point is, so there's that permit in existence and there was the original, which was not fully approved because it needed those amendments, if you recall. Yes, Member Garcia?
Thank you, Madam Chair. And just to hopefully clarify a little more and hopefully not confuse the matter anymore. My recollection is that there was discussion about the fact that Roper wanted to update the permit, and in the last special meeting that we had, we denied their ability to do that and decided that the parties would stipulate to stick with the original permit. So my understanding is we are deciding on the original permit, that was the draft permit that was in the lower hearing.
Yes, you are correct on that. Thank you for that.
Yeah, thank you for that clarification. I'm sorry. I think I may have misstated the situation.
One more question on options. I recall a previous issue where we were at this stage, and as I recall, we did not have the option to basically remand the permit to NMED for reprocessing. Is that true? I just want to be sure whether that's an option we have today or not.
Thank you, Member Honker, for that. I don't know if you want to, if you've reviewed that, legal counsel Rystad?
No, Madam Chair, I'm not familiar with that previous matter.
Okay, okay. So I do recall that discussion. Let me see if, or any other members recall that discussion, and have I'm pulling up my notes here. This matter. So you're asking Member Hunker about our ability or not our, not our ability to remand that back to the
Well,
department.
I mean, my recollection of the discussion, and I hadn't thought of the issue until now, so I didn't do the research on it, but it was a matter of what we were authorized to do by law, what the EIB's kind of charter or directive is by law, and remanding the issue back to the department, I don't think was one of the things that we could do. We're kind of like in a situation like this, we can't do that. But I was just hoping the council might have a little guidance on that. But that's my recollection from an earlier issue. I don't even remember what the issue was, so apologize for that.
Thank you, Member Hunker. And legal counsel, is there, no, you're just coming up to speed on this. What, from your initial review, would there be anything that would prohibit us from doing that in the process?
From remanding it back down,
Correct.
I think that might be an option, but it may not be a previous practice of the board, is what I'm understanding, is that in past that you have decided not to utilize that option, perhaps. But I'm afraid I don't have the detailed knowledge of that particular procedure.
Thank you, legal counsel. Appreciate that. So yes, Vice Chair Trujillo Davis.
Thank you. Apologize for not being there today. I wasn't feeling very well this morning. But I do believe I remember Honker, his comments are tickling a memory back there. I think the the previous issue was that we had to decide on the issue that was presented to us, that and that the option wasn't available to remand it back to the department, that we could only make a decision on what was brought to the board. And I believe it was part of the statute that constructed the EIB. So, but I'm kind of reaching in there on some memories there. We might have to go back and look at some things. But I think that member Honker was on to something there. So I would definitely recommend we make sure on that decision before we move forward.
Thank you, Vice Chair Trujillo Davis. I'm trying to do my notes and check the files. I know I had some there were some comments on that, and there was some discussion on that. So as we deliberate, I'll continue to look at that as well. So thank you so much, Member Honker, for getting us started on the discussion on some of these points. These are important points to delve into and to address in our discussion. So with that, Member Honker, as we review that, did some of the other previous questions and comments by Member Honker stir any other questions from the members of the board on those items? I just want to make sure we thoroughly addressed all of those discussion points. And everybody, yes, Vice Chair Trujillo Davis.
Just to clarify, and I know that I think Member Garcia already said this, but we are deciding on the draft permit, and that Roper had requested a permit revision. Is that correct? Did I understand that correctly?
That's correct.
Okay, thank you. I just
Yes,
want
Member
I
Garcia,
understand.
did you have anything to add to that?
Yeah, I appreciate Vice Chair's question because we all need to be clear on this. I think that the draft permit that was issued and the Deputy Secretary denied is the matter before us now. Even though there had been discussion about various revisions and changes in the work site, et cetera, those were stipulated not to be included in the hearing that we held in October. So yes, we are only looking at the original draft permit.
Yes, Vice Chair Trujillo Davis.
Thank you. I'm just trying to make sure we're moving along the track here. So the the hearing officer's recommendations or conclusions of law that he laid out in his sorry, because he didn't make recommendations. His conclusions of law that he laid out in his report, I believe he had 8 of them. Are those are the ones that we should be using to review that draft permit? Is that, I'm asking this as a question just to make sure that we're all kind of going down the same track here. So.
Absolutely. Thank you, Vice Chair Trujillo Davis. Yes, that's my understanding. And I'm going back to the original petition. So again, going all the way back to the, what started this process and making sure that we're in alignment with that. And I think although the hearing officer's report didn't give specific recommendations on some of those technical items, I think in general, as legal counsel Rystad said, is he did lay out those procedural discussion points. I don't know if anybody else has any other thoughts on Member or Vice Chair Trujillo Davis's points of clarity. Yes, Member Garcia.
Thank you, Madam Chair. Just one other item just to discuss for a moment for the record. I had my memory was that when we appointed the hearing officer, we asked for recommendation, but I went back and couldn't find anywhere that, where that was documented, so my memory may be faulty. Maybe we didn't ask him to make recommendations. So what he did was kind of interesting, and very unusual, I thought. He laid out some of the controversial areas and then sort of gave his comment, sort of an opinion, which was an interesting way to do it. And so those areas are probably the areas that we could focus on, where there was controversy, and particularly the water availability issue, which I'm ready to dive into at any point in time if we're, once we get there. But yeah, I did not remember whether we had asked the hearing officer to make a recommendation or not. And then it's okay. It doesn't mean we can't deliberate today and make a decision. It's just an interesting way that he wrote this report, I thought. Thank you.
Thank you, Member Garcia.
Madam Chair, members of the board, this is Chris Vigil from the New Mexico Environment Department. I apologize for interrupting, but I wanted to offer the statute that empowers the EIB, that defines the EIB's powers. Would you like that for council, so council can look at that and advise? I have the citation if you want that.
Yes, Mr. Vigil, can you provide that to Mr. Reistad?
Yes, that's it's the NMSA 1978 section 74/2-7 H through L. That's the citation, and council will find the EIB's jurisdiction in that citation. Thank you, and I apologize again for the interruption.
Thank you, Mr. Vigil. Appreciate that information for our legal counsel. Mr. Reistad, would you mind checking on that and as we continue discussion? I think I want to maybe address Member Garcia's point to give you some time to check on that statute. So I'm gonna thank you, Mr. Vigil. Member Garcia, yes, I would like to why don't we talk about that water availability issue while legal counsel Reistad checks in on that statute. Did you want Yeah, did you have anything kind of to frame some discussion points you may have on that?
Thank you, Madam Chair. Yeah, I'll go ahead and jump right in. The hearing officer mentioned that the board may wish to consider a process that could be developed under which this issue could be considered and additional conditions imposed, et cetera. And the hearing officer seemed to be intrigued by the argument about the applicant needing to somehow prove that they had access to water. And I know that CEP put on several witnesses talking about that point. Even Eloise Martinez was one of the witnesses, past state engineer, that said he didn't have any knowledge that they had water rights, et cetera. I think that we kind of went down a rabbit hole on that one a little bit. I do agree with the department, and in my past experience as a regulator, it's common to have a permit and conditions in the permit where the permittee is required to do certain things, but they don't necessarily have to show in detail how they're going to do it. They just have to do it. So I think water availability, as the department pointed out, in practice has never been, they've never required that the permittee prove that they have access to water, have water rights, how they're gonna get the water, et cetera. They've never required that they do that, and partly it's because, it's not something that the, Environment Department has any jurisdiction over. It's the permittee's burden to, if it's a permit condition to have a water suppression system, then they have to figure out how to get it done, period. They don't have to prove where they're gonna get the water, how they get the water, et cetera. In other, regulatory agencies, it's a similar practice. You require certain things, but you don't have to, the permittee does not have to show how they're going to do it necessarily. They just have to do it. If it's a permit condition and they don't carry out the requirements in the permit, it could be a violation, and there could be enforcement action. So I feel fairly strongly that the department is absolutely correct that this would be, well, I don't know if they said this would be bad precedent, but I think it would be bad precedent for the board to tell the department that they need to make the permittee prove that they have water rights or prove that they have access to water. I just don't think it's appropriate as a regulatory agency or for the board to require that as well. So that's my 2 cents. Thank you.
Thank you, Member Garcia. Members have any comment? Yes, Member Hong, Member, Legal Counsel Rystad, did you have something to add?
Madam Chair, I think this might be a good time for me to, before we get into the weeds on that issue, I would like to go ahead and read into the record the statute that Mr. Vigil provided. And actually, it does support my position that I took earlier. I feel that the board has 3 different options and I'll highlight that here in a minute. But let me just start by reading. This is again from the New Mexico statutes annotated 1978. This is section 74-2-7, paragraphs H through L. And so paragraph H, a person who participated in a permitting action before the department or the local agency and who is adversely affected by such permitting action may file a petition for hearing before the Environmental Improvement Board or the local board. The petition shall be made in writing to the Environmental Improvement Board or the local board within 30 days from the date notice is given of the department's or the local agency's action. Unless a timely petition for hearing is made, the decision of the department or the local agency shall be final. If a timely petition, this is now moving to paragraph I, if a timely petition for hearing is made, the Environmental Improvement Board or the local board shall hold a hearing within 60 days after receipt of the petition. The Environmental Improvement Board or the local board shall notify the petitioner and the applicant or permittee, if other than the petitioner, by certified mail of the date, time, and place of the hearing. If the subject of the hearing is a permitting action deemed by the Environmental Improvement Board or the local board to substantially affect the public interest, the Environmental Improvement Board or the local board shall ensure that the public receives notice of the date, time, and place of the hearing. The public in such circumstances shall also be given a reasonable opportunity to submit data, views, or arguments orally or in writing, and to examine witnesses testifying at the hearing. Any person submitting data, views, or arguments orally or in writing shall be subject to examination at the hearing. Paragraph J. The Environmental Improvement Board or the local board may designate a hearing officer to take evidence in the hearing. All hearings shall be recorded. Paragraph K. The burden of proof shall be upon the petitioner. Based upon the evidence presented at the hearing, the Environmental Improvement Board or the local board shall sustain, modify, or reverse the action of the department or the local agency respectively. And finally, paragraph L, notwithstanding any other provision of law and subject to the provisions of section 74-2-4 NMSA 1978, a final decision on a permit by the department, the Environmental Improvement Board, the local agency, the local board, or the Court of Appeals, that a source will or will not meet applicable local, state, and federal air pollution standards and regulations shall be conclusive and is binding on every other state agency, and as an issue before any other state agency shall be deemed resolved in accordance with that final decision. And so you will notice that in paragraph K that I intentionally paused and tried to emphasize that this board shall sustain, modify, or reverse the action of the department. And so, and obviously all those other procedures that are outlined, I've reviewed those and I'm comfortable saying that the board followed those along with previous council. And so I feel like that is the issue before you, is whether just to sustain the action of the department below, whether to modify it or to reverse it under this statute. Thank you.
Thank you, Mr. Reistad, for that discussion and putting that on record, that reference and that text. With that, Member Honker, would you want to, I know you had your hand up earlier.
Well, just a little further clarification on the point council just made. I just looked back at the petition from Roper, and the requested relief in the petition was board should reverse NBD's denial of air quality permit application number 9295 and grant the permit as proposed by the AQB. So that's the petition that we have that started this whole process. So now back to water availability. I think I'm in agreement with Member Garcia. I would offer a parallel. The community where I live is on a very small drinking water system. We are required to chlorinate. There's not a requirement that we identify our source of chlorine or anything like that. It's just, you're required to do this action, and you have to do whatever you need to do to have the availability of whatever's needed to meet the permit requirement. Now, I recognize water is far different than chlorine. Chlorine is just a commercial commodity. Water's a little more difficult issue due to the shortage in the state and state regulation. But I do think while I suppose NMED could have put a permit or condition in the draft permit that the permittee shall maintain an adequate supply of water to do dust suppression. That was not in there. It apparently hasn't been put in there in the past, so it looks like NMED has done what they've done for other air permittees, and the addition of this would be a new precedent.
Thank you, Member Honker. Appreciate do any other members have any comments? Yes, Vice Chair Trujillo Davis.
I'm going to also align with Member Garcia and Member Honker in this issue. In my own review of it, I have concerns about tying that level of requirement to a permit. I believe Member Garcia was correct in her assertion that there's a jurisdictional issue with that as well. And I just think it could, just create a lot of mess long term. And there's a reason why the this has been a long-standing practice of the board not to, or of the NMED not to consider that in permit. So those are my comments on it.
Thank you, Vice Chair Trujillo Davis. Any other comments? So I'm gonna just add a couple of comments on that. Currently, I also sit on the Interstate Stream Commission, and one of the things that I find very challenging, having noted issues on the Interstate Stream Commission that may have like water quality or air quality issues when addressing some issues on that side, and kind of the boxes that are laid out in a regulatory and legal process with the state regulatory and legal framework, where each agency or each board or each commission has separate duties and separate responsibilities, makes it very challenging when we have issues that may overlap. But that's the we have and that we all have to operate with and to navigate. And it is challenging, and it is you know, I scratch my head when I see an issue over here and an issue over here, and there's kind of, you would think a way to incorporate those considerations. But again, I go back to the current framework and the current law and the rules and regulations that we currently have to navigate. So with that said, much like Member Garcia, Member Hunker, and of course Vice Chair Trujillo Davis mentioned, is right now, based upon what I understand, it is not within the purview of us to have any decision-making or authority on this board regarding water water permits or water availability. And so with that, I don't see how it can really be considered in our process under the EIB regarding this. There's no mechanism that I see that we could incorporate that in the decision regarding that particular point. So those are my comments, and apologize for going around about, and apologize to the court reporter. I know I glitched there for a minute, but yeah, so those are my comments on that point as well. And also, like, the regulatory framework, I don't know how NMED could then have the authority to regulate that or impose that requirement at this point in time, the way the framework is. I don't know if anybody wants to add any more to that discussion. So legal counsel, I mean, and I think hearing the comments of our board, I think we have, if I can frame it that way, regarding that particular point. I don't know if there's any recommendations on how we kind of memorialize that, or should we wait to a motion or address that in, or just, I don't know, any thoughts you have would be greatly appreciated on that.
I would say, Madam Chair, that just to whatever action you end up or final decision you end up making would certainly incorporate that. In other words, you don't have to express a particular position on that particular issue, just in general, whether the permit meets the standards for air quality that are laid out in the statutes and the regulations. I think that is the ultimate question. And by, for example, if you decide to uphold a granting of a permit, then you are in essence saying that water availability is not an issue without specifically having to address that. You can address that in your decision, but I don't feel you need to specifically point that out. If you were going to deviate from that long-standing practice and require proof of water availability, I think it would be advisable to spell that out in detail. But if there is a consensus not to go down that road, so to speak, I feel like just making a straight up decision one way or the other on the permit is sufficient.
Thank you, Mr. Reistad. Appreciate that. So with that, members of the board, I don't know if there's any further discussion on that, and we can go to other points of discussion. Just making sure. All right, and Member Garcia, thank you for diving in on that one point regarding the water availability issue. With that, is there any other points of contention? At least I know there's the other one regarding the some of the technical matters on the air quality issues. Does anybody want to jump in on that item and share some discussion on that? So with that, members of the board, I know there as legal counsel pointed out, and maybe we'll just go to that point in the hearing officer's report. Legal counsel, do you have that page number off the top of your head?
Yes, it's page 42, Madam Chair.
Thank you.
Oh, I'm sorry, 30. I'm sorry. I don't know where I
35?
got that 35.
Right, okay. All right. I had it on the top of my head, but I wasn't completely certain.
I did too, but I was wrong. It was actually 35. I looked in my notes.
Great. So members of the board, can you go to page 35 just so that we talk about this? I want to address this.
Correct. 35 of the hearing officer's report, right?
Correct. Correct. And this is regarding the air emissions and some of the technical issues. The hearing officer, again, didn't issue a recommendation, just comments regarding this point, bringing it up for our consideration. So I don't know if fellow board members, do you have any comments on this point regarding the air emissions and the modeling? Yes, Member Garcia.
I guess I'll go ahead and dive in. So I understand that during the hearing, there was a lot of time spent by the parties talking about the methodology used for modeling the potential air quality impacts of the facility. And as I recall, CEP had a witness, Dr. Duarte Villarreal, who brought forth a different scenario of modeling that he utilized that would show that there would be an exceedance of the NAAQS. And I also recall, and I went back through my notes, and I do recall that one of the things that the Environment Department modeling expert, Eric Peters, pointed out with the modeling conducted by Duarte was that he didn't have the detailed modeling inputs to review to be able to determine whether or not or how accurate the methodology used by Dr. Duarte, uh, whether or not it was accurate or not. And so the hearing officer made the statement that the record does not show any defects in methodology of Duarte Villarreal's witness. I guess one could say the converse of that is it doesn't show any defects in the methodology, but we also don't have proof that the methodology is accurate. So while they made a very strong attempt to raise doubt about the permittees modeling, the department has a lot of experience. I guess I would defer to the department's expertise. And Mr. Peters has, 10, 15 years experience with modeling and reviewed the permittees modeling scenario. And one thing that gives me more comfort also is that this was based on worst case scenario. And it still didn't show that there would be an exceedance of the NACs. So, so I guess I feel more comfortable with that. And while CEP did, try to raise doubt about whether it was appropriate to use particular meteorological data, et cetera, whatever the permittee provided to the department reviewed rigorously and had some back and forth with the permittee, and then was satisfied that they showed in a worst case scenario there would not be an exceedance. So that gives me some comfort that the information in the application would be accurate. Thank you.
Thank you, Member Garcia. Is there any other comments? Yes, Member Hunker.
Yeah, I'll do a follow-up. I also think in past cases that have come to us, there have been situations where somebody did another technical approach and came up with a different scenario than the department had or the applicant had. And I believe the critical issue is, did the approach that the department accepted, was it consistent with their rules and the law? Was it consistent with past practice? And in this case, it looks like it is. And the fact that somebody came up with another approach that gave a different answer, I think we've seen that before, and we've fallen back on, was the approach taken by or accepted by the department consistent with the law, the rules, and past practice. And my reading of this issue is it is. So I'm in agreement with Member Garcia.
Thank you, Member Hunker. Is there any other comments on this point? If there's not, I'd like to sort of chime in on this one. This is I'm struggling a little bit with this one because I do know we have that process. I know there was some modeling done per the application requirements. And I'm struggling because I do know, these types of facilities do have in the operations, just having had to deal with a number of recently gravel pit operations and also happens and there's the amount of dust and that occurs from these types of operation. Um, and um, and so I was trying to look at the air quality data and the different in preparation for this. And it's again, I think this came up in previous issues that came before the board is you know, mine is like, you know, a air quality station right at the facility. We have to depend on other data in the area, and sometimes that's not totally representative, but we also have these analysis processes that allow for this type of analysis, you know, when we don't have discrete data from a facility or operations. So you know, I guess I struggle to knowing firsthand some of the air quality issues from these types of operations and how it does impact impact local residences and the air quality issues. So I think that's where I'm at. I'm at this point, you know, I love to hear other board comments and thank you, Member Garcia, Member Hunker, for your comments. I guess I'm just trying to figure out, I guess, just knowing what I know from these types of operations and that there is an air quality issue. Now, does it meet the constraints and the based on modeling it, you know, and again, your different assumptions, your different data inputs to any model really, you know, dictate what the outcomes are and the acceptability of the models as what was presented during this hearing and this process. So anyways, that's where I'm sort of sitting right now, still kind of not on all the way. I'm still on the fence here, I guess my point. I don't know if there's any other discussion on that point. So maybe a follow up on that to Member Garcia and Member Hunker is so with I guess what I'm hearing is you're okay with how the department then and the applicant and Roper's model uh, uh, and provided in support of the application, you would be okay with the outcomes of the model in terms of air quality considerations?
Well, I'll start.
Okay.
And I really agree with you, Chair Sweeney. We have gravel mines in my community, and um, they're awful. They're noisy. They're dusty. There's every day I'm behind some gravel truck, and I've had more windshields repaired and that sort of thing. So I really understand the citizens' concern with this type of facility in their area. I do think we have to fall back on the law, the rules, and the historical practice of the department. And there may be challenges to the adequacy of the rules, the law, the department's procedures, but I don't think, unlike the hearing officer suggested, we may want to address some policy issues, and I don't think that's within our purview. I think we have to fall back on what's required, what's been done in the past, and is this consistent? So, yeah, I think it's I'm not seeing that what the department did and accepted from the applicant is out of line with the way they've handled other situations like this, whether it be good or bad. That appears to be what the regulatory structure is. And I think that's the boundaries we have to deal with in.
Thank you for that, Member Hunker. Yes, Member Garcia.
Thank you, Madam Chair. Yeah, I understand that this is a tough one because the opposition CEP did spend a lot of time, and I think their witness, Dr. Villarreal, has a lot of experience with air modeling as well. Probably not as much as the department's air modeler, but his testimony was compelling. So I understand they did raise some doubt, and definitely worth our while to look at it very carefully. But I do realize also that CEP has a big burden to overcome. Their burden is to prove, not just raise doubt, but to prove that the application would not meet the requirements of the Air Quality Bureau, or would exceed the air quality standards. They have to prove that. And so the question in my mind is, did they prove it? And so during the testimony, when Dr. Duarte went through all of the information that he gathered, I was very interested in hearing, well, what did the department think of that? You know, is it that they brought up something that the department needs to relook at? And so when the modeler for the department, Mr. Peters, was asked, what do you think of his modeling? I recall that Mr. Peters, because I was listening very carefully, I recall that Mr. Peters said, well, you know, gee, if I knew all the inputs and everything that was, you know, as you said, input into modeling is everything. that tells you what you're going to get out. So if they had done an adequate job of providing all the calculations and all the information, then perhaps they could have changed the department's mind, but Mr. Peters didn't have that information to evaluate. So I think that what that tells me is perhaps they did not meet their burden to prove. They did cast doubt, but they didn't meet the burden to prove that the application would not meet standards. And so the department reviewed the application, decided that it met requirements with the addition of conditions that were added. With those conditions, that the permittee would not exceed air quality standards or the NAAQS, and would meet all the department requirements. And they've done this a few times at other concrete batch plants or asphalt batch plants that they've permitted. So they've done this a few times, I think. So that's what I'm looking at. Thank you.
Thank you, Member Garcia. Comments from board members? Guess I had a question on burden. I think you mentioned so is it Alto CEP's burden to prove that it meets, or is it the petitioner's burden to prove that they meet it? And I don't know if that's a nuance, but because isn't it the petitioner that needs to meet a burden? Or are you talking about the burden of proof as it related to the application process? I don't know if we're talking about two different burdens.
I think that's a very, very good point you're bringing up, Madam Chair, and perhaps our council can weigh in on that. My understanding, the petitioner, who is CEP, because they're the ones that are appealing the denial. So
Would it be Roper though? I thought Roper was the petitioner. Am I wrong?
I'm going to stop and let our council, that sounds like a legal question, so.
Yes, legal counsel Rystad.
Well, I don't know if I have a good answer, but I can work through those issues. There's a pretty complicated procedural history dealing with the burden of proof and whether the correct one has been used in the past. From my understanding, is that the in the original hearing before the department, there was a hearing officer which may have Gregory Chakalian, who may or may not have used the right legal standard for that. That may have been an error. That is that's the department's position, and I believe in that respect that the department is aligned with the petitioner Roper on this appeal. So as I say, it's a very complicated and maybe unconventional situation in terms of the previous decision and hearing and decision before the department. And I know Mr. Vigil is on the call, and if he wants to address that, he may have been involved in that, Madam Chair. That's certainly fine and at your discretion. I'm just going from a summary of a transition memorandum that I was provided as legal counsel of the background and the procedure in this case. But, you know, my understanding is that there was a burden of proof upon the petitioner, Roper. And if they have met that burden of proof that they can satisfy those air quality standards, which are promulgated, you know, by the Air Quality Bureau, then that's the central question. And at that point, if there's somebody challenging that assertion or that petition, then again, that's where it gets a little complicated depending on the various hearings that have been held. So that's sort of my summary of my understanding.
Madam Chair, this is Tom Nasco. With your permission, I would like to appoint the general counsel to the particular statute identifying the burden of proof in this matter.
Thank you. And can you identify who's talking? Sorry, I can't.
Yes, I'm sorry, Madam Chair. Tom Nasco, I'm the counsel for Alto CEP and conducted the hearing both for the department and before the EIB.
Okay. Yeah, would you mind sharing that statute with our legal counsel?
Yes, as a matter of fact, the legal counsel read that into the record, and hearing officer Chakalian below identified the burden of proof as being on the applicant, Roper. And then the hearing officer denied the recommended denial of the permit, which the deputy secretary accepted. So she denied the permit application. It was then appealed by Roper, who is the applicant, and the petitioner in front of the EIB. And the statute that the general counsel, that the council read into the record, clearly identifies who has the burden of proof. And I raise that only in response to Member Garcia's comments as to raising doubt as opposed to proving beyond a preponderance of evidence. That is not the burden of Alto CEP in this case. The burden is on Roper.
This is Chris Vigil, New Mexico Environment
Let me
Department.
finish, Mr. Vigil, please.
This is not the
Please,
place.
Mr. Vigil,
for-
Mr. Vigil, can you let Mr. Nasco finish and then you can have the floor.
I don't want to be argumentative here, but I think that the board, with all due respect, is going down the wrong path in determining that.
Objection. He's starting to argue.
Proof in this
This is
matter is
inappropriate.
clearly the petitioner. according to the statute. So I would defer to the council to correct that misapprehension in the record.
Thank you, Mr. Nasco. And I think, so the statute that you were gonna recommend was the one that Mr. Rystad, read into the record. Is that correct?
That's correct, Madam Chair.
Okay. All right. And with that, Mr. Vigil, I know you had an objection there.
Thank you.
I apologize, that, we didn't want to get into any back and forth. I want to be careful about doing that in our deliberation.
Yes.
But yeah, so just please be careful as you share whatever you wanted to share. I want to avoid a back and forth here.
Yes,
But-
I just wanted to put my objection on the record, and I'm done with that. Thank you. But I wanted to clarify something. I think that the burden of persuasion that the board is looking for is in the EIB adjudication procedures, and the citation for that is 2020.1.2.302, burden of persuasion. And just brief, well, I'll allow counsel to take it from there, but I think that's going to be the most useful citation for the discussion we're having right now.
Thank you for that. And I know we've been online here for a little while here. With that, maybe is it okay if we take maybe a 5-minute break and then Mr. Rystad, I know, would that give you some time to look at that citation?
Madam Chair, I appreciate that. I'll entertain a break as well as anybody else that needs to go to the restroom or anything, but I have that ready right now to read into the record. It's very short and simple. And then
Okay.
if you want to take a break after that, but it's, as Mr. Vigil cited, this is from the rules. It's 20.1.2.302, burden of persuasion. In a petition hearing, the petitioner has the burden of going forward with the evidence and approving by a preponderance of the evidence the facts relied upon to justify the relief sought in the petition. Following the establishment of a prima facie case by the petitioner, any person opposed to the relief sought in the petition has the burden of going forward with any adverse evidence and showing why the relief should not be granted.
Thank you, Mr. Rystad. And before we go on, I think we can still take a break, but I know Vice Chair Trujillo Davis, you had your hand up.
Yes, I was hoping you'd give us 10 minutes.
Okay. Well, 10 minutes then. So in 10 minutes, we'll be back, and thank you, Mr. Rystad, for that. Back in line here. You good to go? Awesome. All right. Thank you all for taking a minute and with that, and we ended with Mr. Rystad's reading of the discussion item that we were having a few minutes ago regarding the burden of persuasion, I think it was referred to.
That's correct, Madam Chair. That's under the New Mexico Administrative Code for adjudicatory procedures given to this board, the authority, the procedures to follow under the authority given to this board for this type of adjudicatory procedure.
Thank you so much. Appreciate that. Okay. Okay. So we're back, and I think that burden of persuasion under 20.1.2.302 that was provided. Again, going into our burden of persuasion and a burden of proof discussion prior to the break. Member or Vice Chair Trujillo Davis, do you have any comments?
Well, I think just to kind of getting us back on track here, I believe Member Garcia's, sorry, Member Garcia's point was that where the burden of proof lied in the first decision. Is that correct, Member Garcia? That's where what you were asking?
Yes, thank you, Vice Chair. Yes, I think, let me just correct myself. I did misspeak earlier. I said the petitioner was CEP. I was thinking Roper and CEP came out of my mouth, but it is Roper. I understand that. So I just want to correct the record. But I see by this burden of persuasion in the rule that whoever is trying to appeal to a body, they have the burden to show why their position is correct. I guess to paraphrase and take it out of legalese and put it into everyday language. So originally, Roper had the burden to prove that their application was appropriate. They had that burden, and the department decides whether or not they met it. The department secretary or deputy secretary decided they didn't. So then the petitioner becomes Roper, who then has the burden. Wait a minute. I'm getting myself mixed up. To me, CEP still has a burden to prove that that their position that there's something wrong with the application and it won't meet the NAAQS. I think somehow, to me, they still have to prove that, but I may be wrong on that point. So the council will correct me now. Thank you.
Thank you.
Thank you, Madam Chair. No, I believe that's a correct statement of that rule or code provision that we're discussing, the burden of persuasion. Any person can be an organization like Alto CEP. So they are the ones opposed to the relief sought in the petition, which would be granting the permit. So it's shifting the burden to them. They have the burden of going forward with any adverse evidence and showing why the relief should not be granted. So that was the testimony of the modeling that you all were discussing earlier. Did they meet that burden of persuasion? That's what you have to decide, I believe.
Vice Chair, Member Hunker, sorry.
Well, to phrase it another way, the way I'm seeing this is there was a decision made by the Deputy Secretary of NMED based on the first hearing officer's report and recommendation that the applicant had not met their burden of proof. The applicant's now saying, no, that decision was wrong, and we did meet our burden of proof. And so we're basically having to relook at that same decision that was made in the initial permitting process and make our own determination on those arguments. That's the way I'm seeing this.
Thank you, Member Hunker. Vice Chair Trujillo Davis.
And if I understand correctly, the Environment Department submitted comments on the hearing officer's report. And in that document, if I'm reading this correctly, that they are asking us to reverse the department's denial of the draft permit because it was wrongly decided and is contrary to law. Is everybody else kind of caught up on that as well? But that is, if I'm understanding that correctly, they are also asking us to reverse that decision.
Yeah, so I just want to maybe add to that points of clarity. So they I mean, the deputy secretary, I guess, in some sense, is the department, right? Or their department representative. And they made the decision. So I, and so this is a little bit more complicated because now we have they own the department saying they want to, through this process that we're going through, this hearing, to undo the decision of their own department. Vice Chair.
So then to keep going, then then the burden of proof falls on to Alto CEP to prove that that modeling was not correct. Is that good? We're good?
Well,
Mhm.
that's where I'm still a little bit confused because Alto CEP is not the petitioner.
Madam Chair, this is Tom Nasco. May I comment on that issue?
Uh, okay, just please, again, be careful. I don't want to
Yeah,
have a back and forth here.
absolutely, I understand, but I think there's some fundamental confusion on the difference between the burden of proof and the burden of persuasion. They're two different things. The burden of proof is to establish that all air quality standards have been met. If it, and only if, this board believes that Roper has made that showing, then Alto has to come back with a burden of persuasion to show that why the burden of proof was not met. Alto does not have to come back and show definitively that the modeling is incorrect because of incorrect AP 42 haul road emission factors or otherwise, but Alto can point out in the burden of persuasion why the burden of proof has been met because of an issue the board has not yet discussed with the artificial
Objection, I apologize, I
haul road
object.
distances. No,
Mr.
I gotta
Nasco
finish, Mr. Vihil, I gotta finish.
Nasco is not board counsel. Mr.
Right,
Nasco
right.
is not
Mr.
counsel for the board.
Mr. Vihil, I thank you for that. And again, Mr. Nasco, I know, let's make a reference that our legal counsel can refer to. I think we
Absolutely.
have all the references. Is that correct?
I think that the legal counsel had transposed the idea of burden of proof with burden of persuasion. Burden of persuasion is not the burden of proof. Burden of persuasion is to come forward with facts that show that the burden of proof has not been met. And in the hearing officer's report, there's specific discussion on the use of improper distances for haul roads, improper AP 42 emission factors, and so forth.
Yeah,
So that is sufficient in the burden of persuasion. It's not our burden of proof to go forward and show why the permit should not be, why air quality permit standards have not been met. It's our burden of persuasion to show
you.
that the burden of proof has not been met.
thank you, Mr. Nasco.
Madam Chair, if I could
yes.
address that, I'm going to object that is a mischaracterization of the comments that I made as your counsel. I simply read into the record the NMAC, the Administrative Code Rule 20.1.2.302, burden of persuasion, and then some of the board members discussed that rule. And, you know, again, I want to redirect your attention as a board to the hearing that was held in October. That's when Mr. Hanasco had his opportunity to make his legal arguments and present Alto's position, or Alto CEP's position. This is not the appropriate forum at this time for him to be interjecting his legal arguments, as Mr. Vihil pointed out. He had that opportunity. There was a lengthy hearing held in October, and we have all that evidence. You have all that before you. You have the hearing officer's report. The board simply needs to determine whether those standards were met at that hearing. And it's simply a review of that hearing at this point.
Thank you, Mr.
I need to
Longstaff.
lodge an objection, Madam Chairman. I apologize. I'm here on behalf of Roper Construction because Mr. Lou Rose is ill. He told me to just attend and watch, that there was no argument of counsel permitted at this meeting. So I'm a little surprised that I'm in a position of having to lodge an objection just in case we end up on appeal that counsel for Alto CEP has lodged argument and attempting to introduce evidence in what is the board's review procedure. Again, I apologize. I feel like I had to put that on the record in case there's an appeal. Thank you.
Thank you. All right. All right. Okay, our court reporters. Yes, Mr.
I
Bach?
don't know who that was that just spoke. Can you help me out with that, please?
Yes, ma'am, can you identify yourself for the record? I think that was
sorry.
legal counsel.
Shelley Dalrymple with Montgomery and Andrews. I do not represent Mr. Roper in this proceeding. I represent him in the other litigation brought against him. But I'm here on behalf of Lou Rose, who was too sick to appear and who is counsel of record in this matter. Thank you.
Thank you. Okay. Yes, all right. Member Hunker.
Yeah, I would just suggest that since we are deliberating, that the discussion be restricted to the board members and our council, unless we specifically ask somebody else a question. That's not in our group. I think it's getting a little bit beyond the bounds of what we're supposed to be doing here.
Absolutely. Thank you, Member Hunker, for that clarity. And so, yeah, thank you again for legal counsels for being here on behalf of your clients. And I think at this point, I appreciate Member Hunker's points of clarity here. And I see head shaking by our legal counsel, Mr. Reistad. So that's, as we go forward, I think that's what we'll be doing, is just maintaining our board members and our legal counsel discussion on the record here. And again, I apologize. We should have just maintained the points of reference for our legal counsel. For points of reference of statutes and and any other documentation, but going forward, we'll maintain that that direction. So with that, members, do you have any other comments regarding this? Is there still any more confusion on that? I mean, I think why we're here today, again, just point of clarity, is yes, we have the Roper appeal, and it, like I was sharing earlier, did get more complicated because NMED issued the denial initially in this process, in this administrative process, the overall, and then we had now the department and Mr. Roper on this side, and then Alto CEP, but it is Roper's petition to start off our hearing. Am I correct, legal counsel?
That's correct, Madam Chair.
Okay. Does that help provide clarity to our board where we're at and how we got here? Good. And I know you had like a follow-on there, Vice Chair Trujillo Davis. So does that help clarify? So we're here because Roper is the petitioner. And for where we are right now, NMED is supporting that petition, but Roper is the petitioner.
Yes, I think we're good, and I apologize. There was a lot of back and forth there, and I lost wherever I was going with that, but thank you for bringing us back around.
Okay. All right. Wonderful. Thank you. All right. So with that, and apologize, I'm not in person there in the room. I think it's, you know, some of these issues then become harder virtually to navigate. So we can continue our deliberation and discussion. So with that, does that provide any more clarity as to the points of this this issue regarding the air quality? Yes, Member Garcia.
Thank you, Madam Chair. And just to make sure we're all on the same page, so CEP has the burden of persuasion, and correct me if I'm wrong, please, counsel. CEP has the burden of persuasion to persuade us that the permit should not be issued and that we should sustain the department's denial. Is that correct, counsel?
That's correct. That was their burden at the hearing in October, was to show any adverse evidence why the permit should not be granted.
Okay, great, thank you. So if CEP has the burden of persuasion to persuade us that there's something wrong with the issuance of a permit, then I guess going back to what I said earlier, I would maintain that while they did cast a lot of doubt, they didn't, to me, satisfy that burden of persuasion to convince me that the department's modeler made a mistake in the analysis of the modeling in the application. So that's sort of where I sit. Thank you.
Thank you, Member Garcia, and I apologize hitting on this and legal counsel. So by the burden of persuasion, the petition hearing, the petitioner had the initial burden going forward with the evidence. That's Roper, is that correct?
Yes, Roper was the petitioner. That's correct.
Okay, so where now you're saying the following the establishment of a prima facie case by the petitioner, now Alto is the person opposed to the relief and now has a burden going forward. Is that what your point is?
Let me reiterate, my point was that Alto CEP had to satisfy that burden of persuasion to go forward with any adverse evidence back at the hearing in October. And this board's role at this point is to review that evidence from that hearing and determine, as you've been discussing on these issues, whether they are able to do that to the point that you feel like the permit should be denied.
Okay, and that's because the petitioner Roper established the prima facie.
Well, the department was aligned in that position in the initial part of the procedure, is my understanding. So they are saying that going forward that was established, there was a prima facie case. And then Alto CEP was challenging that apparently with their modeling expert at this point in particular that you're discussing at the hearing in October.
Okay, okay. I think I'm finally there. Okay, so Alto is not the petitioner. I just want to make sure that's clear, right? Okay,
That's correct. They would fall under the language in this administrative code provision that we're discussing. Any person opposed to the relief sought in the petition. They are
gotcha.
opposed to the permit.
Okay, okay, I'm there. All right. So with that, is there any other discussion on the air modeling? And thank you, Member Garcia, for being patient with me. And so we go back to now, therefore it is Alto CEP's discussion and burden to demonstrate their model, or that there are issues with the acceptance of Roper's modeling. Is that correct? Member Garcia?
Yes, sorry, yes, that's correct.
Okay, okay. And then on that point, you feel, Member Garcia, I guess back to way back a couple minutes, half an hour ago, that the modeling done by the department and by Roper as the applicant. And again, we talked about the modeling, but that's where we are right now. And there's no, does the board, I guess not just you, Member Garcia, but do you board members feel good with the modeling that that I would say that Alto CEP did not meet the burden of proof to have to go opposed to the modeling presented by Roper and supported by NMED. In other words, that the modeling sufficient by Roper and NMED given the current inputs.
Yes, if I could just add to what I was saying
Yes.
previously, is that, you know, as Member Hunker pointed out before, we've kind of been down this path in another case, as I recall, where a hearing officer suggested that the folks who were opposed to a permit introduced enough doubt to make the hearing officer decide that maybe the permit shouldn't have been issued. That happened before. And in this case, I think in the lower hearing, the hearing officer was persuaded to some degree that there was enough doubt introduced that maybe the permit shouldn't have been issued. And I guess my point in all this is that it's not enough to introduce doubt. I think they have introduced doubt. You know, that's their job. And they introduced enough doubt that we all had to pay attention and look carefully at the evidence. But doubt is not enough. You have to prove, in my mind, you have to prove that the department was wrong in issuing their draft permit. And I guess I haven't been completely satisfied with their case as of yet. So just another way of saying the same thing, I guess. Thank you.
Oh, wonderful. Member Garcia, thank you. That point of that discussion and those points. Yeah, members of the board, do you have any other comments on this? Do you feel comfortable where we're at regarding the modeling? Yeah, okay. All right. So I mean, I think it's still to your point, Member Garcia, I think there's still, I mean, much like the previous issues that came before the board is, again, it's the inputs and kind of the technical side and having to look at the existing models and the various approaches to figure out, to contradict a model. And I see now with the burden of persuasion clause that was provided that then it falls upon Alto CEP to sufficiently provide that adverse evidence regarding what Roper has provided in the application. All right, so it looks like I don't know if there's any other discussion on that. If not, just trying to look at the members. You feel comfortable with where we're at now on that? Thumbs up? Yep. Okay. All right. And Vice Chair Trio Davis and Member Bitzer, are you comfortable where we're at? Okay. How about you, Vice Chair? Yeah, okay. All right. All right. And thank you all for your patience of waiting through that. I think that was one of the major points of confusion that we had. And legal counsel, I think we've covered some of those points in the hearing officer's report that were major items. Is there anything else that we haven't covered from your initial review? I don't see anything.
No, thank you, Madam Chair. I would just, when you do take a vote on a motion to this, I would just recommend or advise you to make in your findings of fact and conclusions of law on the record that you feel one way or the other that whether the use of the AP 42 emissions factor used by Roper and approved by the department are the accurate ones that should be used. Like I said, one way or the other, whether you, because that was the issue that was raised in the hearing officer's report, and just to show on the record that you are deciding that issue since he didn't take a position on that. I feel like that's the main thing that has to be addressed there, and that will probably help in future matters that are similar to this.
Thank you, Mr. Reistad. All right, so with that, members of the board, I know you've had time to review the hearing officer's report. Are there other points that you would like to bring up regarding that report as we continue deliberations? Yes, Member Hunker?
Well, to me, and we've kind of talked around this, but we haven't actually addressed it. This is a very unusual situation where the applicant applied for a permit, Alto CEP objected, made their case. The first hearing resulted in recommendation to deny the permit, and then the department denied the permit. And then when it was appealed, now the department is agreeing with the applicant and is saying, and I'm reading from the department's comments on the current hearing officer's report, the one we're looking at today. Department's denial was wrongly decided, is contrary to law, and would reverse decades of department policy. We can't overlook that. I mean, that's I've never seen a situation like this before. Those are significant arguments by the department regarding this petition and in favor of the petition. And it's to me, those are some serious things that we need to be aware of, consider, discuss, etc. So, in effect, the department is saying the rationale used in their early decision was flawed, was not consistent with law and decades of department policy. So, I mean, we can't ignore that. I don't think we have to take that as the gospel, but that's a very significant position that we need to consider, I think.
Thank you, Member Honker. Any other comment? Yes, Vice Chair Trujillo Davis.
Thank you. I wanted to go back to our counsel, Mr. Reinstad's comment, and there was a question raised or about the AP 42 emission factors and putting that on record. There was a question or a comment raised by NMED about the board's jurisdiction over the use of that standard. So I was wondering if you could maybe give us some guidance on that issue.
Well, all I can do is point you to the hearing officer's report on page 35, where he discusses that issue. That was part of the legal arguments and the evidence presented at the hearing that you had in October. I have not had an opportunity to review all those records from that hearing, just this hearing officer's report. But I think, again, you would need to take a position on whether the use of the AP 42 emissions factor for paved roads for this facility is more reflective of the actual conditions at the site of the proposed facility than the AP 42 emission factor for cement batch plant haul roads. That was the contention made by, again, depending on what kind of modeling you used, whether it's for the cement batch plant haul roads or for paved roads, which has been the longstanding practice to use that standard. And it sounds like there was a discussion a few moments ago where board members were and maybe are reaching a consensus or working that direction towards stating that the use of the factors for the paved roads would be more appropriate to follow the longstanding practice in that situation.
I'm sorry, I probably need to be more specific. In the in MED's comments on the hearing officer's report, they make a point in there that says the board does not have jurisdiction over the applicant's use or the department's acceptance of the AP 42 emission factors. And so I just wanted guidance if that was indeed the case or not, if the board does have jurisdiction over that decision or not.
That would be for this board to decide whether the department is correct in that statement. I mean, they provided argument to that effect, and I can't tell you one way or the other whether they're correct or not. That's I can simply state that that was a point of contention in the hearing and in the comments to the hearing officer's report. And there's no in the hearing officer's report itself, there's no discussion as far as he was not an attorney, so there's no legal discussion there. But the department does have attorneys and have analyzed that. So you would just have to decide whether to affirm their views or not.
Okay, thank you. And I'm kind of still kind of driving at here is just to make sure that there wasn't anything within the statute or regulatorily that would prohibit us from making that. And you're saying no, there's not.
That's correct.
Okay.
And thank you, Vice Chair Trujillo Davis, and maybe to take that one step further. So I guess, so how would we as a board address the opinion of legal counsel for NMED's statement of that we don't have the authority, but yet if we were to make a motion regarding this specific issue of looking at the AP 42, if I can, is that kind of along the line of what where you're going, Vice Chair Trujillo Davis?
Yes, thank you. That's a really good follow-up to where I was trying to get to.
Yeah, so if we have to make a decision, but then how do we is there, and maybe is there a statute that we could point to or a citation that does give us that authority? Or if we are in alignment with what the department says, or if we don't have the authority, then can we even address that particular issue? So I guess that's where I'm going. Yes, Vice Chair Trujillo Davis.
Yes, that's exactly what I was kind of driving at there. There seems to be a conflict in the legal opinion of whether we have the authority to make this decision or not.
Excuse me, Madam Chair.
Yes, Member Garcia.
Yeah, I think you can't see me waving my hand over here, so I thought I'd interrupt, sorry. So if I may help frame this a little bit, perhaps. I hope I don't muddy the waters even more, but I think since the use of AP 42 emission factors is discretionary on the department's part. In other words, the AP 42 emission factors are not regulations. If they were regulations under the department's purview, then the department has to use them. They have to. And then we could, as a board, then say, you didn't use them, you should have, you were wrong. In this case, AP 42 emission factors are a guideline that, in my understanding, the department has discretion whether to use or not. And in some cases, they use them, in other cases, they don't. They have that discretion. So, and we've dealt with these before in a previous case, whether or not they should have been used, I do recall in a previous case. Since it's a guideline, it's not a regulatory requirement. It's up to the department whether a permittee uses them and which ones they use. So in this case, I guess I would defer to the department as to whether AP 42 emission factors are appropriate, which factor is appropriate to use. So, you know, different than a regulation, it's a guideline. Thank you.
Thank you, Member Garcia. So if I may, Member Garcia, maybe ask a follow-up and your thoughts on this is, so if it's a, so are you, I guess, if it's a guideline and we're not, so in, I guess, whatever decision we make, whether to support or oppose the, a permit, denial or approval, is it in our, do we base that on, so we, maybe, I guess, how would you form that we address that issue on page 35 of the hearing officer's report? Like, or would you, can you frame it better than I did, Vice Chair Davis, my question?
Well, I kind of following up here on both Member Garcia's and your points there, but we did have an issue, and I do believe that NMED brings that out that we've previously seen for air quality permit 8585. And that was I believe, if I remember correctly, that was the asphalt an asphalt plant that was located outside of Santa Fe or in Santa Fe. And that we did conclude that the board does not have jurisdiction over the applicant's use of AP 42. So I'm just pointing this out as consistency purposes, since I do remember that hearing and those discussions of the use of AP 42 as a guideline and as a tool for the modeling, and that there were other ones available, but that was the most commonly used one. And I'm not, if I believe in this case, the question is which AP 42 standard should have been used rather than should AP 42 have been used. So although for purposes of consistency, we did say that we did not have jurisdiction over the use of AP 42, but that may be a little bit different than the question being asked. I'm sorry.
Thank you, Vice Chair Trujillo Davis. Any thoughts by members of the board on this? Oh, so if I may then go back and say, so um, so if we don't have to the reference that Vice Chair Trujillo Davis pointed out, so if in, you know, in terms of consistency, we don't have the, it's a guideline. How do we address, that point in the hearing officer's report, and or maybe this would be for legal counsel. How do we address that point if we have to make a decision on the AP 42 question? Do we just say we don't have the jurisdiction or, you know, authority on which to utilize?
You can take that position based on the previous case that the vice chair mentioned that you've decided. You can also, and again, generally your guidance by statute is pretty vague and broad. That's the way a lot of statutes are written. And so in 74-2-7 that I read into the record earlier, again, in paragraph K, what you're charged with as a board is to sustain, modify, or reverse the action of the department. And so that doesn't give you a lot of guidance as far as the details of how you would reach that decision. But if, you know, you can say, for example, that you think the wrong modeling was used, that you were not, you know, persuaded, or that you were persuaded by the modeling that the department uses. And you're not telling the department which one to use. You're simply saying, as a decision-making board, what helped you to reach the decision that you're going to reach. You know, was it the modeling that Roper and the department are relying on, or is it the other modeling that was mentioned for the other type of roads? That's, you know, that's within your purview. That if you feel like this other, you know, modeling should have been used, you can go that route. But it sounded to me as earlier as though you were at about the point of a consensus that you would defer to the department's judgment.
Thank you, Mr. Rystad. Okay. Even though it's vague, I think I see how it can how it's been more clarified. So thank you. So with that, Vice Chair, I know you brought this point up, and I had the same question. Do you feel comfortable where we are at with this point that was brought up by NMED in their submittal?
Yes, I think that the point of deliberation for us is if they use the correct, if NMED's modeling was correct in the AP 42 standard that was used.
Okay. Well, with that, is there any other points in that we need clarified that board members want to clarify in either the hearing officer's report or the submittals by Roper or Alto CEP? Okay. So with that, I don't have any others other than the one that Vice Chair Trujillo Davis, in addition to the ones that our legal counsel brought up, that I have any questions or comments on. Is that you, member Garcia?
No, I didn't raise my hand, but I guess
Okay.
I'll speak to that just very briefly. I do have a little bit of a question for our council. Mr. Rystad, you suggested that we make a decision about the AP 42, use of AP 42, whereas it appears that if we're deciding whether to sustain, reverse, or modify, if those are our three options, then we're looking at the modeling as a whole, not just the use of AP 42, but it's modeling as a whole, whether or not CEP proved to us that the applicant should have used different AP 42 standards, used different inputs, used different meteorological data, et cetera, in their modeling. So to me, the broader question is modeling, whether we accept that CEP showed that the applicant was wrong in their modeling. But I think you said we need to make a decision about AP 42. Is that correct?
Let me rephrase it this way. What I'm suggesting is that you enter, again, I'll restate this first part and then I'm going to rephrase the second part. The first part of that is that you do enter findings of fact and conclusions of law on these contested issues, because the hearing officer did not take a stance on that, and that would be an important legal part of a document which memorializes the decision that this board is going to make. So that's just the general part of that needs to be addressed. Now, you can be as specific as you want or as is possible in those findings of fact and conclusions of law. You know, generally, the more specific you are, the better. I will state it that way. Whether you have to get into this issue of jurisdiction and the specific modeling is in your discretion. I may have misspoken when I suggested that you need to go that far into detail. I just want to make sure that the record is clear that when you make a decision that you're making findings that support one side or the other. And again, generally speaking, the more specific you are, the better. But you know, in particular, if the department is taking the position that they don't have the authority on a particular issue, if you're deferring to that and you're sustaining their decision, you don't have to specify, you don't have to get that far into the details as far as what modeling they use, whether they need to use modeling or not. You can, but you know, again, you don't have to. If they've taken the position that they don't have jurisdiction, and that these are just guidelines as it's been discussed, then if you're, for example, if you are affirming that decision, you don't have to go into great detail in that particular reference.
Thank you. That's very helpful.
Thank you, Council Reistat, for that. Are there any comments or thoughts from members of the board on legal counsel Reistat's summary? I think that was helpful. So with that, and I apologize for kind of going back a little bit. So if there were doubts that were provided or that, you know, that Alto CEP had regarding to what Vice Chair Trujillo Davis, what you point out, maybe not the model itself, but what standards to utilize or what then I guess in a motion though, we would just say that there may be, I mean, I'm just trying to get myself off the fence here. And maybe this is to legal counsel. There would be doubts, but not the maybe level of burden of persuasion to get us to the point where we would overturn the department. Because now it's Alto's responsibility to or burden to overturn the department stance. Is that correct?
Right. In other words, you could say there was conflicting evidence on some modeling standards that were used at the hearing in October, and we take position X or Y on that issue. You know, so that's kind of how I would look at that.
Thank you. Yes, Vice Chair Trujillo Davis.
I'm going to stir the pot a little bit. I I was looking back through the evidence because I didn't know if anybody or had remembered why the different standards were used. So I was looking back to the evidence to kind of remind myself, and I did not attend the hearing. I had to go through all the documents on my own. So it wasn't something that stuck out to me when I was reviewing it. So is there, does anybody have anything to contribute on that topic of, you know, what was the difference and why did they choose to use the different standards? I'm just curious.
Yeah, members of the board, do you have any, I gotta look at my notes too, but on that point, and please chime in. I'm gonna look on my notes here. So if I don't see you, just jump in on Vice Chair Trujillo Davis's question. Let's see. And so you're just asking, Vice Chair.
Yes, I just wanted to, and I was looking back at Mr. Wade's, or I'm sorry, let me go back and see. I was looking back at the testimony about from CEP about the use of the standard, and I think that Member Garcia brought up a really great point about the department having. I'm sorry, let me think about how I'm phrasing this so we don't get too muddied here. But Member Garcia brought up a point about being confident in the modeling that the department had done, and if there was enough doubt raised to satisfy the burden of persuasion, which made me wonder, well, how much do you have to, what do you have to do to show that there's doubt? And obviously it's through the evidence and through and so I just decided to review it real quick and make sure I had all the information. And so I was trying to find the reason that they chose to use the paved roads versus the I want to say unpaved roads, but that's not the correct term. The concrete batch plant emission factors. So I was just looking for that citation. Does that help you out there, Chair?
Yes, thank you. Appreciate that. No, for those that were in attendance at the hearing, again, I'm just chiming through my notes here. Do you recall? Member Garcia or Member Hunker, were you at the hearing as well?
I was, and I looked through my notes and I couldn't find.
I know. Okay.
I'm reviewing the rebuttal testimony now, just not remembering off the top of my head.
Right. So with that, Vice Chair Trujillo Davis, I mean, looking through my notes here. Sorry for the delay here. I'm looking through my notes here.
And I apologize for taking us down this kind of off into this path here, but I believe we had a lot of public interest on this issue and so I just want to make sure that we do our due diligence and deliberate this issue because of how much public interest this issue did raise.
Yeah, thank you for bringing this detail up. I want to make sure too that we address all of these details. So again, I think this goes back to Member Garcia and Member Hunker, our discussion about the modeling and the inputs and what is used in the model in the analysis. And I think
Madam
yes,
Chair,
Member Garcia.
I did find in the NMD rebuttal testimony on page 8 where they speak to the use, which factor, silt loading emission factor to use. The Bureau determined that the silt loading emission factor of 12 grams per meter squared was not appropriate because the proposed haul road will be controlled, and this emission factor did not take into consideration control measures applied to haul roads. So I do recall that was one of the areas that they went back and forth on, was considering the water suppression system and the sweeping and wetting of the roads, et cetera. That's why the department thought the applicant used the appropriate silt loading factor. I don't know if that helps.
Yeah, thank you for that, Member Garcia. And then I'm looking also at Alto's submittal to their comments, and it goes back to this burden of proof question as well. Is in their submittal, they believe like NMED's denial of the application is sustained because Roper has not met its burden to establish that construction and operation of the concrete batch plant will not exceed air quality because of the use of the correct AP 42 value for paved roads within a concrete batch plant. Well, that will increase emissions from the haul roads by a factor of 15. So again, it goes with that burden of proof question. To kind of go down that rabbit hole that you started us on, Vice Chair Trio Davis, and then comes in that testimony by Alto's expert regarding that. And I think that's where then we're ending back up, kind of circling back around to the one of the crux of the thing, the decisions that hearing officer had discussed about the modeling and what our position is as a board. And so I don't know if you want to look at that. It's on Alto's submittal on page 22. And it's the Alto, let's see what document this is. Alto's CEP's comments on the hearing officer's report? So I think it just really takes us back to that crux of the question of, was I think this is where the doubt is as well, that we've been kind of touching upon throughout our discussion items. The AP 42 and those assumptions and standards. I don't know if that helps address your questions, the kind of worm that you were referring to.
Yes, thank you. I think we have a lot of, or I've had a lot of places to review, and kind of help bring that into focus for me.
So with that, I apologize putting you on the spot, Vice Chair Trujillo Davis, because this is where I get back on my fence, right? Like, so do you feel that based upon what you've read and the material that those applicable quality standards were utilized, pay versus some of the assumptions that were brought up, one by the department and then by Alto CEP?
Yes, and I certainly understand the position that both of them took as far as why the department used the standards that it did and why CEP felt that they were the incorrect standards. And it's brought up more clarity to the two different standards, because I admit I did not quite understand the discrepancy there, but now kind of bringing this back, reminding me what it was. I am still a little unsure. I mean, I think we're looking at the whole of the issue. I understand the points that they were making, and then why the water issue became more relevant later on. And so I'm putting all the pieces together and making my decision here. That I apologize if that's not clear, but
Yeah, thank you, Vahio Davis. And this goes back to my comment earlier, knowing how gravel operation, I mean, not gravel, but these types of operation are, and knowing, having been around similar facilities, and I do know this area. I have some work down in the Rio Doso area, and I drive by Alto on my way to Rio Doso at times. So I do know the how, I guess, how the location is, and the I guess the roads and the infrastructure around this area. So I mean, I do understand some of the concerns that the public has brought up, and again, it goes back to the assumptions for me, the model, and I think personally, I think there's doubt. That's kind of why I'm still on the fence, like, and to your point, as you just mentioned, Vice Chair Trujillo Davis, is n- I I guess I that's where I'm at still.
uh,
Yes.
I think it might might come back to a question of, policy on some level here that, a permit was issued with certain stipulations and restrictions and it's under the department's purview to enforce that permit with those stipulations and restrictions on them. And based on the information that has been provided in it. And so I think we're kind of, and I'm just giving commentary here. I think that that's kind of coming down to the decision here of the issue is what is in the permit and what is enforceable and what is policy.
Thank you, Vice Chair Trujillo Davis, for that comment. Any other board members have any comments? So, I mean, I think we're at a point where we've kind of touched upon some of these major issues, major decisions within that we need to address. Trying to see there in the room. Do you feel like we're at a point where we can make a motion? Board? Yeah, you think so? So does one of the board members want to venture into framing a motion? Or have questions of how we could frame a motion? Know what your thoughts are? You want more discussion on these items?
I guess
Yes.
I'll go ahead and, I'll go ahead and try it. So, after our discussion and deliberation, I would make a motion that we reverse the department's denial of the permit based on the evidence presented at the October hearing. And while there was conflicting evidence regarding modeling methodology and various other scientific inputs, the Alto CEP did not meet their burden of persuasion to persuade the board that the permit should not be issued.
I'll second that.
Thank you, Member Garcia, Member Bitzer. I want to look to legal counsel. Does that look like to be a good motion?
Yes, and I
is
was
there-
shaking my head, which is not part of the record, but I agree. I think that was framed very well.
Thank you. All right, so we have a motion on the floor and a second. Is there any further discussion? If not,
Yeah,
okay, yes, Member Hunker.
sorry, I turned off my individual video. You couldn't see me. I do think, NMED's position makes this very unusual. That NMED took the action and they are now saying that was incorrect, contrary to law, et cetera. Normally, we would have had a consistent NMED opinion going through this, but I do think with the current NMED department input and it tilts me to agree with Member Garcia's motion. It made it very tough to try to get my head around all this stuff in light of that kind of flip flop. But I agree with the motion.
Thank you for that, Member Honker. Is there any other comments before we go into a roll call vote from? Yes, Member Bitzer.
I just want to commend Member Garcia for being able to put that phraseology right on the first try, first shot on goal. That was beautiful.
Thank you.
Thank you. And if there's no other comments, I just want to make one more comment. You know, I think I think the point of clarity for me, I think Member or Vice Chair Trujillo Davis, you brought up the difference between the previous issue of whether the modeling guideline use of AP 42 on that other issue was you know, was the crux of the, you know, that the use of AP 42, where we don't have that. It's a difference of this one more than just the use of AP 42. And so I think that's where I feel comfortable on moving forward on that point, where it was a little more of a point of a decision of whether to use it or not. But where I still stand, I think, is a little bit of doubt as to the standards on, and of course, like I said in the beginning, any model is highly dependent upon the initial assumptions in order to get an analysis out. So that's where I'm at. But if there's no further discussions, I'd like to look to Ms. Corral for a roll call vote on this.
Member Bitzer, how do you vote?
I vote yes.
Member Garcia?
Yes.
Member Honker?
Yes.
Chair Suina?
No.
Vice Chair Trujillo David?
Yes.
The motion passes.
Thank you, Ms. Corral, for that roll call vote. And I appreciate the deliberation, and I want to apologize for kind of it getting out of control there for a few minutes, but I appreciate the discussion and all the work that members of the board have done in order to get this this matter addressed and reviewed, and just the thoroughness of everybody's work on this. So again, I'm honored and humbled to be and your wealth experience is just great. And then of course, legal counsel Reistad, thank you for delving into a very complicated deliberation and issue, and just highly grateful for your support on this.
I really appreciate that, and I just want to thank all the members of the board for their service and all of your wealth of knowledge, because you know, you overlooked my faults, and I appreciate that. And I'll probably be working with you for at least a couple more meetings, so hopefully I'll do better next time.
You did wonderful. Thank you for stepping in. So if there's no other comments, I know we have another board meeting scheduled next month, and we'll be in touch to see if there's any items that that are on our agenda. So stay tuned, board members. Yes, Member Honker.
I believe there's a hearing on an OSHA proposed rule that I'm serving as hearing officer at next month's board meeting. At least that was the, I think that was the decision we made. I have not heard that that's changed. So, Mr. Eisted, I'll send you a note about that in terms of giving me a little help.
Thank you.
Thank you, Member Honker, for that.
Member Honker, just a quick heads up, my uncle's memorial, is scheduled now. It'll be, late April. So
Am I still online here?
April 21st is when I'm flying to Seattle, so it's that weekend.
Am I cutting out?
We hear you.
We can hear you, but Chair Swinner,
Oh,
you're just picked up.
we just lost you.
Are we
Can you hear me still? Okay, okay. Let me see if I can get back. Oh. Can you hear me now?
Yes.
Yes.
Oh, apologize for that. I was trying to get some signal here.
And I'd like to thank Member
Apologize, I
Bitzer.
missed that discussion. Is there anything I missed as I was trying to get signal?
I just mentioned, Member Honker that, the William Ruckle House Memorial is gonna happen, up in Seattle weekend of, I think, April 21st is when I'm flying out, so.
Okay, okay, wonderful. Well, thank you, everybody, again, for your participation and all your work and your service. Appreciate it. Apologize for my lack of signal here. Is there any other discussion points? If not, the next item on our agenda is adjournment.
I will move we adjourn.
Thank you, Member Honker. Is there a second?
I'll second that.
Okay, thank you, Member Bitzer. And with that, Ms. Corral, would you mind doing a roll call vote?
Member Bitzer, how do you vote?
I'll vote yes.
Member Ely?
I vote yes. Wait,
Member Garcia?
Yes.
Member Honker?
Yes?
Chair Sweeney?
Yes.
Vice Chair Trujillo David?
Yes.
Motion passes.
Thank you all. I hope you have a wonderful day and weekend. Enjoy springtime, right? We just started spring.